Okay, any preliminary matters that we need to discuss on behalf of the state?
Generally, when we get to that point, we do have jury instructions
Okay.
are completed. I've got the defense proposed set of mitigating circumstances in there. We'll have to have some discussion on that, and I believe everything else as far as the rest of the jury instructions is sufficient.
Okay, I do intend to address that. I wasn't going to do it this morning, but I do intend to address that. Anything else on behalf of the state?
No.
Any other matters on behalf of the defense?
No.
I do need to address with Mr. Bradley whether he intends to testify in this phase of the trial. Is this an appropriate time to do that?
He's not going to be testifying. Basically, it's discussed fully. His decision is that he will not take to stand this trial.
Okay, can we make sure that the microphone is on at the defense table? If y'all could touch that microphone for me just to make sure if it's on. No? Can we turn on the microphone at the defense table? Digital recording, if you could hear me, if we could turn on the microphone at the defense table. Okay, they haven't done that. I know they're here. I mean, he might just have to stand up and come up to the podium. I was just trying to save him the trouble of doing that. If you could touch the microphone again. Yeah, he'll need to come up. Mr. Bradley, I'm going to have you come up and step up to the podium if you could, please. Okay, Mr. Bradley, your attorney has represented that in the penalty phase of the trial that you are not going to testify. Did you hear your attorney make that response?
Yes, ma'am.
Okay. And you do have the right not to testify if you choose to do so in this phase of the trial. You also have the right to testify in this phase of the trial if you choose to do so. Have you had enough time to discuss this issue with your attorney?
Yes.
Do you need any additional time to discuss this issue with your attorney? And your attorney has represented that it's your intention not to testify in this phase of the trial. Is it your intention not to testify in this phase of the trial?
Yes, ma'am.
Are you taking any medication at this time? Have you taken any medication today? Did you take your medication yesterday?
Yes.
And how does the medication affect your ability to think? Can you think more clearly with the medication or less clearly with the medication? Or does it not affect your thinking at all? Okay. Are you thinking clearly today?
Yes.
Okay. And do you understand what is happening here today?
Yes.
And has anyone, including your attorneys, pressured you into not testifying? And is that decision your own decision? Okay. Okay, thank you, sir. You can be seated. Okay, I don't think the defense has rested on the record. So when we come back, we'll need to do that first. And then, is the state ready with rebuttal testimony?
Judge, after considering it over the weekend and taking the deposition of the doctor yesterday, the state has decided we're not going to be presenting any rebuttal testimony.
Okay. That kind of changes the course of the proceedings for the morning.
Yes, ma'am.
Then what we'll do is do you need the jury instructions to do for purposes of closing?
Well, yes, it would be helpful to deal with the mitigating circumstances. And I think as the dividing of things proposed, we don't have protection or standard. Right? So, yes, we need that.
Okay. I need the microphone at their desk turned on. Okay, can we touch it? It's not activated.
They were working on them yesterday, and they were not working right.
They maybe been turned off so long they don't know how to turn them back on. I don't know. I can hear that. I can hear that.
That's not, yeah, I don't think that's not.
Yeah, I can't. That's not doing what it's supposed to do. All right. If you could call digital recording and tell them, I just want to make sure that this is being recorded and that they're picking everything up.
If I can approach with...
Yes. Thank you, sir. Okay, if you could tell the jury that we have an issue that we need to address, and it's going to take a few moments, so if they desire to go get some coffee or be downstairs for a few minutes, I don't want them, I don't object to them getting coffee, I don't object to them walking outside and smoking if they wish to do that, but I don't want them to mill around in the general public. Okay. Okay, I have no doubt I'm being recorded. I mean, with all due respect, I'm concerned about the two parties being recorded. They just changed it from jury trial to on the record. If you'll touch your microphone. That's all right. Okay, now we're good. We'll just do that. I think in jury trial mode, they've got yours turned off. Okay. I want to ask, since the defense is going to rest on the record and the state is not presenting any rebuttal evidence. I do have another question for Mr. Bradley at this phase. Mr. Bradley, are you satisfied with your attorney's representation of you during the penalty phase of this trial?
Yes, ma'am.
Okay, is there anything else that you would have requested that your attorneys would have done differently?
No, ma'am.
And is there any additional evidence that you desire for them to present?
No, ma'am.
Okay. Okay, thank you. Okay, then with regard to let's go ahead and do the charge conference and go over the jury instructions. Okay, I'm looking at the first page of the instructions presented by the state. Any objection to the first page?
No objection.
I haven't read through these, so I'm assuming that you all have read through these. I thought from what I heard you had no objection to this whole packet. Is that correct? Or can we go through 1, 2, 3, 4, the first 5 pages?
Well, let me just look at some of these, and I'll have a response.
Okay. Digital recording, when I want the attorneys to be on the record, I'll just go to on the record. And then if we want to shut off the mics, I'll go to jury trial.
Your Honor, I have these objections as to the proposed aggravating circumstance of cold, calculated, premeditated. When Dr. Olander testified, she said that Mr. Bradley was not capable of engaging in calm, cool reflection, which is the language in the definition portion of that instruction. She said that he was not capable of engaging in a careful plan, which is another essential element, as it were, for that aggravating circumstance. That being the only testimony as to those elements that have been offered in the penalty phase, that there is insufficient evidence and to go to a jury, and I would move for a directed verdict, judgment, or acquittal on that basis as to the cold, calculated, premeditated jury instruction. As the court knows, as the instruction provides, premeditation is a heightened degree of premeditation. It's not fair. Premeditation is defined in the standard instruction. It requires these additional aspects of it. The ability to engage in calm, cool reflection, which has been the only evidence on that, was that Mr. Bradley could not engage in that, did not have the capacity to do that, in the opinion of Dr. Olander. And also on the careful, that there had to be a prearranged or careful plan, and Dr. Olander's opinion on that has not been rebutted. So that there is insufficient evidence to go to a jury. I move for a directed verdict, judgment, or acquittal on that aggravating circumstance, and I've got some issues with a couple of others. The court wants to deal with that, and we can move on after the court rules.
Okay, response from the state.
Judge, our position is it's a question for the jury. It's a factual question. That was Dr. Olander's testimony, but the jury has to decide whether to believe that or not in light of other, what we argue, conflicts and issues with her forming her opinion. In this particular case, we have what we know from the time the cameras turned on, 3 minutes, 52 seconds. We know that the vehicle, police Deputy Pill was observed prior to that, coming at them, and then she had to make the turnaround, and it's only after she made the turnaround, got behind the car, turned her lights on, that we then, the video started running, preceding that point by 30 seconds. So we have at a minimum 3 minutes, 52 seconds. Our argument is we have quite a bit longer than that at the time frame when the discussion actually started between the defendant and Andrea Kirchner, that he was going to have to kill her. So you have, in our position, a lengthy period of time. It's certainly a murder that was calculated, cold, premeditated. We think there's enough there. There's certainly no pretense of any moral or legal justification. Judge, I would cite the court to Vale v. State, which is 581 Southern 2nd 40, Florida Supreme Court case. May I approach?
Yes, you may.
Judge, in the Vale case specifically, it's on page 9 of the printed copy I gave to you in the section under headnote 20. They cover the factual circumstances. In this particular case, they had approximately 8 minutes elapsed between the initial stop and the murder of Officer Pena. Our case position is a little different in that the discussion starts prior to the stop, the defendant announcing what his plan is, what his intent is. This particular case, the officer shot it from a distance of 1.5 to 3 feet. Ours is a distance of less than 2 feet or less. Approximately 2 to 5 minutes elapsed from the timing, the time when the defendant left Officer Pena's car to get the gun and slowly walk back and shoot and kill Officer Pena. Here, well, we don't have that time frame because he's actually with the gun from the beginning. The Supreme Court, and they cite to the trial court, and the trial court found that these actions established not only a careful plan to kill Officer Pena to avoid arrest, but demonstrate the heightened premeditation needed to prove this aggravating circumstance. This was without any doubt an execution-type murder. It was committed without any pretense or moral or legal justification. Officer Pena did nothing to provoke or cause the defendant's actions. This aggravator factor has been proven beyond a doubt to the exclusion of every reasonable doubt. The Florida Supreme Court then goes on, we believe these facts were sufficient to sustain a finding that the murder was cold, calculated, and premeditated. Ours is factually fairly similar to this scenario, and I think it's a jury question for cold, calculated, premeditated. Judge, we've also previously given you Griffin v. State, which is 639 Southern 2nd 966, and that's another case where the court upheld the finding of CCP in the murder of a police officer, and it's on the last page, page 9. I can give the court my copy that I have, if you don't have it with you. This particular case, as the facts were summed up in the sentencing order that the trial court upheld, the defendant, after committing an armed burglary and robbery, stated to both Mr. Terrell and Mr. Velez that if they were pulled over by the police, he would get out and shoot because he was not going back to jail. 26 hours later, the defendant committed another armed burglary. While driving away from that scene, there was the stop, and then the killing of the police officers. He got out of the car and started shooting. So in that particular case also, the court upheld CCP for the killing of a police officer, and I think combination of both these cases, and certainly the Vale case, because I think factually it's very similar to what we have here. It certainly stands for the proposition that this should be a jury question, let the jury decide, and then the court, if the jury recommends death, the court makes the final decision in its sentencing order.
As Mr. Brown pointed out, that case is similar, but it's distinguishable on the lack of evidence supporting the conclusion or any evidence that could go to the jury on calm, cool capacity for calm, cool reflection. Let me read the instruction here. It says cold means the murder was the product of calm, cool reflection. And I'm looking at Val, that there's no testimony one way or the other on the capacity to engage in such a thought process. There were experts who testified about extreme mental or emotional disturbance, but nobody weighed in on this particular element of cold, calculated, premeditated. And so, while similar, it is distinguishable in that one of the critical elements of cold, calculated, premeditated is missing. There's not enough evidence to go to the jury on the capacity. There is evidence to go to the jury on the capacity to engage in calm, cool reflection, and the evidence is he didn't have the capacity to do it. So the cold element has not been established. The only evidence establishes that Mr. Bradley did not have the capacity to engage in such a thought process. These are separate elements. They're distinguishable. While the state can argue that there is a careful prearranged plan, that's one of the elements. And the other essential element is it's got to be cold. And as defined, the only evidence related to that by Dr. Hollander is that he did not have the capacity. Not that it was just impaired, he didn't have the capacity to engage in that. So there's no evidence to go to the jury on that particular aggravating circumstance because of the evidence of testimony of Dr. Hollander.
The request by the defense for judgment of acquittal with regard to number 5 is denied. I will allow that to go before the jury. Okay, other arguments on behalf of the defense as to the first 5 pages.
Your Honor, on the issue of, on cold calculated, premeditated also, that without any pretense of moral or legal justification. A pretense does not mean actual moral or legal justification. That means that there is, at least on the surface, as believed by the defendant, a justification for it. And the evidence for that is his belief, whether right or wrong, whether accurate or inaccurate, that he was going to be shot. And the evidence for that is in the testimony of Andrea Kirshner, who says that Mr. Bradley said that immediately preceding the shooting. I'm afraid she's going to shoot me. That Mr. Bradley said to the police when being interviewed, that was the reason for it. I thought I was going to be shot. That's what he said to Dr. Hollander. That's what he said to Dr. Zapp. But more to the point is what Mr. Bradley was heard saying in the few seconds before the shooting. And that is, why are you going to shoot me? At least 3 times. So it doesn't have to establish in fact that this was a moral or legal justification, a pretense. And the only evidence on that is based upon Mr. Bradley's concern, as expressed at the time and subsequently, that he was afraid that he was going to be shot, and the reasons for it. So the state, the only evidence on that, it being adverse to the state's position, the court should grant a directed verdict on that because there's no evidence to go to the jury. A reasonable hypothesis of innocence is that that's what Mr. Bradley believed, whether right or wrong. That's why the word pretense is in there.
Okay, response from the state?
Judge, if you look at the jury instruction, the definition of a pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of the murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. So the jury would have to find that he believed that was his pretense. Just because he says it doesn't mean they have to believe it. Our position is the evidence shows it's to the contrary, that that's just simply something he was saying. But even if they find that was the defendant's real pretense of moral or legal justification, that then rebuts the otherwise cold, calculated, or premeditated nature of the murder. So by its definition, it's a jury question. To weigh that, to decide, was that really his pretense of moral or legal justification? And if so, whether that's enough to rebut the otherwise cold, calculated, premeditated nature of the murder. And that's a jury question.
Okay, the court does believe that that's a jury question, so that argument by the defense, the court will not adopt that.
Your Honor, we'd also object to the proposed aggravating circumstance of to avoid arrest in conjunction with the victim being a law enforcement officer. That would be doubling. They both deal with the same aspects of the case. They should be considered as one, but actually the court should not give both to the jury.
That's number 6 and number
4.
4? Okay. State's argument with regard to that.
Judge, they should both be given to the jury. There is case law that does indicate that those 2 aggravating circumstances in the killing of a police officer would constitute doubling. However, the case law is pretty clear on is that you instruct the jury
as to those. We've included the doubling instruction in the packet, and that's what the Florida Supreme Court requires, because there's no telling the jury whether they find one or the other. If they find both, then they can consider both, but it's considered one aggravator, and that's the extent of it. And then obviously the court makes the final decision, and if the jury comes back with a recommendation of death, then the court would combine them in your sentencing order.
Okay, where's the doubling instruction?
Judge, it is following the aggravators. The very next page, the top one, and that's the standard instruction for doubling that the Florida Supreme Court has put out.
The problem I have with that, Your Honor, if the court knows going into it that the case law establishes that those are in fact doubling as aggravating circumstances, then the court should recognize that and remove one of them from the jury's.
But doesn't the case law say that you're supposed to, that it's proper to give them both and then...
Or instruct the jury that number, that numbers 6 and 4 are double. Because otherwise, the jury's left with to possibly say, well, yeah, there are separate, these are separate. We're going to find both of them.
We'd ask the court either to strike one of them or to instruct the jury on the law, which is the Florida Supreme Court has held that the two of them together constitute doubling and are to be considered as one and only to be accorded weight as one aggravating circumstance. If that's the law and that's what the court's recognized, the court is not bound by the standard. The court can take into account whatever the law is, and that is the law in this death penalty case, that those in fact constitute doubling. The jury should be informed about that. Because the state will be arguing that they're not, and that's not the law. The law is that they are.
Okay, response from the state.
Judge, we're aware of what the law is, so we're not going to be arguing that they are, that they're not, but the jury has to make a finding. If they find we've proven one and not the other, that's why you give both. And there's no case out there that I've seen, and I can't imagine that it's there because I've seen the cases that deal with this, that instructs the court that you do not give one to the jury, because then you have to decide which one do you not give. So the cases are quite clear. You give them both. That's why there's a doubling instruction. If you didn't give the doubling instruction, that would be error. That is part of our objection. The other part is if the court is not going to remove one of those aggravating circumstances, then inform the jury about what they are. What those two aggravators are is they merge into one. That's what the courts say, and it's discretionary with the court. As I said, the court, as the court knows, is not bound by standard instructions. The court can instruct the jury based upon the law, and that is the law. And if the court needs a case, if the court wants a case for that, I will be glad to provide them.
Well,
they should know exactly what
I reviewed some of the cases with regard to this because I thought this might come up, and it's my understanding in reviewing the cases is that you have to give both instructions and that you give this doubling instruction, and that's what the case law says is proper. I'm not aware of any case that says not to give the two aggravating circumstances, and I'm not aware of any case that says in the doubling instruction to specifically point out which two you're referring to. So if you know something, if you have case law out there that says something different, I'd be interested in seeing that. But I'm not aware of any case law that says that, but I'm open to, if there's case law out there, then I'm happy to review that.
Well, would the court accept that the two are considered to be double merged by the Florida Supreme Court? And if the court wants a case to hold that, it shows that, and we'll be glad to provide it.
No, I accept that. I accept that.
The second part of the premise is the court is not bound by the standard instructions. The court can fashion instruction which accurately reflects the law. And if the law says that the two are considered merged, then why should the jury have to even try to sort that out? Why would they be deliberating on that issue, which is a non-issue? because they could, and contrary to the law, they could consider them separately, give them separate weight, and which would be contrary to the law. And then the damage is done. And so the only way to obviate that is to instruct the jury on the limits that the courts recognize that are placed on these two aggravating circumstances. They are merged. And so if that's the law, then it's within the court's discretion, and I respectfully request the court to follow the law and instruct the jury on the limits of their deliberations and what they can do with those two merged aggravating circumstances. Court's discretion. And there's no law, case that I know of that says the court has to. But again, it's discretionary. The court can follow the law. And the court should, with all due respect, especially in this case.
Okay, I think the instructions as proposed are appropriate. So I'm not going to make any changes as to those. Okay, anything else from the defense as to these proposed instructions?
Get back to where I was, Your Honor.
Judge, the court could read both as one. Two sentence, a one paragraph aggravator, but not given a separate number. And I believe Mr.
Bradley's rights under Florida and U.S. Constitution would require that.
Okay, response from the state as to that request.
Judge, the trouble is, by doing that, then our argument would be the jury would be only finding part of an aggravator, which is not the case. So they may have a tendency to give less weight. I think the Florida Supreme Court's covered this, not only with these two, but in other circumstances where it's doubling, and they've said consistently, you give both, and you give the doubling instruction, and I'm just asking the court follow what the Florida Supreme Court has approved in numerous cases.
Okay, that request by the defense is denied.
Your Honor, the basis for our objection to those aggravating circumstances and all the instruction modifications that we're asking for would be the Federal Constitution, Amendments 5, 8, 5, 6, 8, and 14, and the Florida Constitution, Article 1, Sections 2, 9, 16, 17, 22, 23. And I'm still looking at the instructions.
Do we have these up on the computer?
Yes.
Are they easy to make changes?
Yes. Well, I believe they are, yes.
Paragraph 2, second sentence, there's a spacing issue.
Is that the list of aggravators?
That's the list of aggravators.
Judge, that one is not easy.